Hello, Iowa Realtors. I am Eric Malloy, your 2026 president, and I'm here with Justin Hayes, our legal counsel. And Justin, what are we going to talk about today?
We are going to talk about text messaging and real estate.
Why is this an important topic?
Okay, so look, here's the deal. You guys do a lot of business on these supercomputers you carry in your pockets, right?
Yep.
And not just business, but you handle personal matters as well. And so when you've got this one device that contains all this information on it, it's very easy for you to slip out of business mode and slip into personal mode and send a text that you maybe shouldn't have sent and get yourself in trouble. And I'm not talking about a wild text. I'm talking about you are casual when conducting your business and then you slide into a troublesome situation.
Okay, so what are the potential issues with using text message as an essential part of a realtor's business?
Yeah, so a couple of things. First off, text messages can become evidence in lawsuits, first and foremost. Your phone can be subpoenaed. It could be evidence in lawsuits, but not just that. It could be evidence in code of ethics proceedings as well. We frequently see text message exchanges in code of ethics hearings. Also, it becomes part of the transaction record. Those text messages you have with your clients or with the other realtor, that's all part of the record now. So you have to keep a record of those text messages with your file. There's fair housing concerns, because again, you can get very casual with your language if you're not really on point when you're sending a message. There's disclosure concerns, and then last but not least, it could serve, like those text messages can serve as proof of unauthorized promises or promises you shouldn't have made as part of your practice.
Okay, so let me give you some examples of what could potentially be risky statements that could be used against an agent.
Yeah.
Down the road.
Absolutely.
So, what if I said, don't worry, this inspection issue is a minor issue?
Don't say that.
And why is that bad?
Yeah, no, it's a couple of different issues. So first, you're minimizing a material defect, right? You have knowledge of this thing, but in order to keep the deal moving forward, you're trying to minimize the impact of this thing. The problem is, what if your client relies on that statement? What if you don't have actual knowledge of the seriousness of the problem? And now, between your conversation with your client, like your client asks for a repair on that thing or chooses not to ask for a repair on the thing, and you find out later the seriousness of the issue and it costs the client thousands of dollars, right? Or just a substantial sum of money. You minimized an issue that they could have investigated, and you're on the hook for doing that. So,
Okay.
Something to keep in mind.
Yep, that makes sense. What if I shared to maybe the other agent, like, hey, I think my seller would take less?
No, I wouldn't send that one either. This is going to be a whole list of don't do this, right? But look, you're implicating your fiduciary duty to your client there, right? You've got this duty of confidentiality. You are indicating to the other side of the negotiation that your client has, I don't want to say like a vulnerability, but like they have flexibility on an issue that the other side doesn't need to know about. That's none of their business. And so you've disclosed that confidential information now. Your client didn't allow you. I'm assuming your client didn't give you permission to do that.
Okay. We are looking at houses in a particular neighborhood, and I say to you that this is a great neighborhood for young families.
And now,
Through text, obviously.
through text, and now you've just created a fair housing violation. So,
But it is a great neighborhood for families, don't you think?
it could be. I don't know. I don't know the neighborhood, right? And I don't have any young kids, so I don't know what kind of
Okay.
neighborhood they're going to be looking for. But what you could say is you can let them know factually that the neighborhood has like parks and schools nearby.
Okay.
Those are factual statements, and they can infer from that what they want. They can investigate how they want in terms of your client, right? But once you start to implicate young families, that's a fair housing issue.
Okay. We come upon an issue during the transaction, and I say to you as my client, don't worry about that right now. We can fix that after closing.
Are you fixing it? Am I fixing it? See, that's the issue, right? First off, that statement doesn't provide any clarity. So if I, as the client, am told that we can fix it after closing, I'm assuming that you've got some involvement in actually getting the thing fixed. And if the fix requires costs, I'm also assuming that you've got some liability for those costs. And then what happens, again, like in the earlier situation, where those costs are much higher than we anticipated because we didn't understand the seriousness of the issue, well, now you're on the hook again for potentially at least half of those costs because you've implied that you're involved in helping me fix the thing.
Going a little further with this particular topic, what if I text you and said, I, as your agent, will take care of that and pay for that after closing.
You better be ready to be on the hook for whatever the cost of the thing is, and for the act, and also fixing the thing to your client's satisfaction. Probably a bad idea just in terms of a business practice. It's kind of like, like shoveling snow or raking the lawn for your client. Like, yeah, maybe you can do it, but is it the best idea? Probably not.
Okay. We have an issue with the transaction, and I say to you that, you know what, we can figure this out. You probably don't need to use an attorney.
Nope, absolutely not. So, from a legal perspective, unauthorized practice of law. From a code of ethics perspective, Article 13, unauthorized practice of law. You are now giving advice on a specific situation that probably crosses the threshold into legal advice because you have evaluated whatever the situation is and determined that the services of an attorney are not necessary. That, in my opinion, crosses the line. If, when in doubt, go talk to an attorney. Let them give you their opinion on the thing. But, I don't know, just be careful. Be careful.
Good advice. Any other concerns that you think we should be aware of?
Yeah, a couple. So the first one would just be consent and privacy. So like, if a client texts you, that's one thing. They are impliedly saying, hey, I have reached out to you. I want you to respond to me on whatever the thing is. That's implied consent. That's fine. But where you start getting into having an issue is if you're doing any kind of like advertising or marketing via text message and you've not obtained any kind of consent from the person that you're reaching out to. What is it? The Telephone Consumer Protection Act, requires express written consent prior to sending any kind of mass marketing text messages. And so that consent has to be in writing and the client has to understand what they're signing up for. So again, be careful with what you're doing, what you're using your text messages for. Excuse me.
And final thoughts. Do you have any tips for realtors looking to stay on the right side of the law when it comes to text messaging?
I do, and I typically do, right? So first, assume that every text you send will be read in court someday. And especially if you're using your personal phone for your business, every text that you send.
So what if you delete your text messages? Are they still able to capture those?
I would assume so, yeah, from the service provider. Okay. So there's going to be a record of those text messages somewhere, even if you think you're being slick by deleting the messages from your actual device. And also the other side of the transaction, or whoever you're texting, has a copy of those texts as well. So assume those texts will be read in court. Also, if you're doing any negotiating or you're disclosing anything, in my opinion, that stuff is best kept formal. So like, put it on an actual writing, email it to the other party, or like honestly, if you don't want to put it on an actual writing, it should still probably be in an email, but keep it formal. Other things I would say would just be like, when you're actually using your phone to do business, avoid slang and abbreviations, like do what you can to increase clarity, make sure everybody understands what you're talking about. Don't have sensitive discussions with your clients on your phone if you can help, like in text messages if you can help it. And then last but not least, just keep records of your communications. Keep records of those text messages that are pertinent to the transaction in your transaction record. So, yeah.
All right. Well, thank you very much.
Yeah, thank you.